Now that we understand the difference between historians and political philosophers and public policy analysts on the court from 1986 to 2020, I need to talk to you about what's happening on the Supreme Court and what has been happening, clearly has been happening since the end of the 2021-2022 term. We have a common understanding that what the court is doing now is a form of originalism. It is not. It is something different. What the court is doing now is changing the intellectual approach of Antonin Scalia in favor of a broader use of history in a way that we haven't seen before. The technique is called history and tradition. And some scholars are calling it living traditionalism. Now, to understand what history and tradition is, we need to talk a little bit about how the Bill of Rights, specifically the First Amendment, was applied to the states, and what happened when the Bill of Rights, the First Amendment, was applied to the states. In the early 1830s, the court was asked in a Fifth Amendment case dealing with the right of eminent domain, should a business owner get just compensation if somehow the state had taken away his business? In this case, they had ruined his wharf where he would offload goods from a ship that would be tied up to the wharf in the Baltimore harbor. John Marshall, who was a nationalist, who was a federalist, who loved the central government, would have loved to have said, yes, the Fifth Amendment in the Bill of Rights protects you, Mr. Barron, and you should be repaid by the city of Baltimore or the state of Maryland for your lost business. But remember, John Marshall was in fact an originalist because he had been in the debate in Virginia about the First Amendment and the Bill of Rights and whether or not to ratify it. And he had voted to ratify it. And he knew that the First Amendment began, Congress shall make no law. And that's where he started here. Unfortunately, he said in the opinion to Mr. Barron, when the First Amendment, which actually was the Third Amendment, there were 12 amendments that were sent to the states for ratification, and only 10 of them were ratified. The other 2 had to do with whether Congress could raise its own salary or only raise its salary for future Congresses, became the 27th Amendment in the late 20th century. And there was an amendment that was not adopted and still hasn't been adopted and won't be, about the size of the voting district for Congress. So the First Amendment, Congress shall make no law, was actually the Third Amendment. But Marshall says when you begin Congress, that first word, it tells me that they intended only to apply the Bill of Rights to the national government, not to the states. And he said, I was in the ratification convention. I know what the people were saying then. Our fear was not the state government. We supported the state government. I was a Virginian. Our fear was the national government would become like King George III or would become like the British Parliament. And so we were trying to encase and add to the Constitution the rights for individuals, and those rights would be protected from regulation by the national government. Well, after the Civil War, John Bingham of Ohio and the radical Reconstruction Republicans wanted to make sure that the Emancipation Proclamation of 1863 by Abraham Lincoln would be enshrined in the Constitution. They wanted to make sure that those people who were enslaved in the South and in the Middle States, those people would be freed. They wanted to make sure that if those people were freed, it could be relied on in the Constitution. And so we have the 13th Amendment banning any law dealing with badges and incidents of slavery. But if you have people who are freed, you want to make sure that they have the right to vote. And so the 15th Amendment gives those freed slaves the right to vote. And there was a long period of trying to implement that in the South and some of the middle states. But if you have freed citizens, it's not enough to say you just get the right to vote, because there won't be enough votes there to have the laws passed in the states to protect them in daily life. And so, what Bingham did is he led the Congress to draft the 14th Amendment. And the 14th Amendment tells us that persons now will be protected for their privileges and immunities. They will be protected against a lack of fairness by the government, due process of law, life, liberty, and property. And they will be protected for the equal protection of the laws. His hope was to try to enshrine in the 14th Amendment broad enough protections so that the freed persons, the former slaves, would now be able to say, I have something protecting me from governmental regulation, from being punished for things I did not do. One of the things John Bingham wanted to do with this 14th Amendment is he wanted to overturn that earlier case of Barron versus Baltimore. He believed that the best articulation in American government of all of the privileges and immunities of everyone were the 10 Amendments, the Bill of Rights. And he believed that his privileges and immunities clause would apply the Bill of Rights to the states, all of them in total, as they were written. It was a lovely goal and debatable as to how many people actually believed that Barron versus Baltimore would be overturned. It is less than a dozen, probably, roughly half a dozen, maybe, but nevertheless, it becomes a debatable point because within a matter of about 5 years, the Supreme Court heard a case of some people who owned meatpacking firms, slaughterhouses, and they were objecting to the fact that the state of Louisiana had passed a law, corrupt law, that was designed to have a state meatpacking slaughterhouse operation, and it would replace all the individual business owners and businesses in that state. And there were hundreds and hundreds and hundreds of slaughterhouses in the state of Louisiana. So in the slaughterhouse cases of 1873, the Supreme Court heard the question of whether or not the taking of those businesses, just like in the Barron versus Baltimore case, was a violation of eminent domain. If, in fact, the privileges and immunities incorporates all of the Bill of Rights, if, in fact, that happens, then the Fifth Amendment of the Bill of Rights should, in fact, protect those slaughterhouse owners. The Supreme Court did not hold for the slaughterhouse industry. The Supreme Court said the only thing that is protected in the 14th Amendment are the national citizenship rights, the national privileges and immunities. And since it does not deal with state privileges and immunities, you cannot use the Privileges and Immunities Clause. Effectively, it's like they took a magic marker and just simply wiped out the Privileges and Immunities Clause in the 14th Amendment. Well, it's a long, involved story about what happens next, and it goes from about 1868 to really the last couple of years, as the court, in case after case after case, debates a new question. If the Privileges and Immunities Clause do not apply or incorporate the Bill of Rights to the states, would it be possible to redefine the meaning of the Due Process Clause of the 14th Amendment to say that just because of fairness, we can take a piece of the Bill of Rights, define it as due process, and since the 14th Amendment applies to the states, no state shall deny these rights, then maybe the state can't deny this piece of the Bill of Rights. Well, the court goes back and forth over the meaning of these rights. I won't deal with that now. I wanted you to understand the debate that was happening around 1866 to 1873, when the 14th Amendment was being created, debated, ratified, and then it was being analyzed by the Supreme Court in 1873 in the slaughterhouse cases. There's a very eminent legal scholar named Kurt Lash at Richmond Law School, combined with an equally eminent legal scholar, Akhil Amar, at Yale Law School. And they proposed the idea that this very concept of taking a piece of the Bill of Rights and putting it through the 14th Amendment fundamentally changes the meaning of those rights. I want to read just a quotation from Kurt Lash. Under a system of popular sovereignty, the distinction between words as proposed and words as ratified has important implications for the content of constitutional law. Words are invested with legal validity only to the extent that they represent communicated will of the people themselves. Originalist theorists embrace this distinction and maintain that determining the meaning of a constitutional communication requires determining the understanding held by those with the sovereign authority to speak fundamental law into existence. In short, what Professor Lash is arguing is, whatever the meaning of the First Amendment or the Bill of Rights were in 1788 or 1791, when you take those words and you now say, well, you're not actually going to apply the First Amendment or the Bill of Rights to the states, you're going to apply the words due process of law, and a piece of that will be interpreted as the First Amendment or the Bill of Rights. It means that you are now wiping the blackboard clean and you are saying, we need to know what the Bill of Rights meant in 1866 to 1873. We need to know what happened when the people of that era, when they passed and ratified the 14th Amendment, re-speak the amendments. And so some originalists say, I'm not going to go back to 1788 to 1791 to define what the people understood those Bill of Rights to mean. I'm going to go to 1866 to 1873. What did they mean then? And that process gets you a very different and varied result. There is a large debate going on in the originalism community about this. Well, that concept of being able to shift eras in our country's history and shift the meaning of those amendments has been expanded, I think, by Justice Alito, by Justice Thomas, who is now working on what I think is his third version of originalism, which isn't originalism, it's history and tradition, and Justice Neil Gorsuch. Because what they're saying is, I now get to pick and choose which era of our history I'm going to look at to compare the case that I'm deciding now to what the people understood this right to mean in this era. And I need to cross-check that meaning with whatever I see the meaning to be in 1788 to 1791. And I will tell you by looking at different pieces of history and different thinkers and different cases in this late 19th century era, or just focusing on the 14th Amendment and its ratification in the late 1860s. And I will choose whether or not I'm going to follow what's in the 1788 period or what's going to happen in the 1866 to 1873 period. And then these justices can say, after looking at the American experience, maybe I will or maybe I won't look at what happened in English experience. It's very confusing. Some critics of this whole area call this law office history. And they say that what the justices are doing is they are looking at the briefs of the law firms that are filing briefs to the Supreme Court on different cases, and they're picking and choosing different periods of history, picking and choosing different laws, different cases, picking and choosing different historians. And they're coming up with what they wanted to do initially when they decided this case. So nobody can really tell what's going on in history and tradition. And that's why there was such a furious debate in the end of the 2021-2022 term with the Dobbs case, D-O-B-B-S, that overturned Roe v. Wade and the right of a woman to choose to get an abortion. And the Bruen case, B-R-U-E-N, the Bruen case, which fundamentally changed the gun rights decision of Antonin Scalia in 2008 that I talked a little bit about, the Heller case. New York had said, you cannot take the guns you're going to use for target practice to your shooting club because you're leaving your house and you're driving to the shooting club. Just leave your guns there and drive to them. But the litigants were saying, oh, we're not safe when we drive from our home to our shooting club. So we need the right of self-defense in our car outside of our home. So would Clarence Thomas, who wrote the opinion, say, I will do what Antonin Scalia did in the Heller case? And would Clarence Thomas say it's a right of self-defense, but only in the home? No, that's not what Clarence Thomas did. What Clarence Thomas did is he used history and tradition, and he jumped from era to era in United States history. And he said, what I'm looking for here is the historical analog. I'm looking for another law just like this one. And if some historical period had a ban against the use of guns outside of your home, then that historical period will justify me upholding the New York law. But if I can't find a historical analog, then I won't allow this law to exist. I've got one. It's called Tombstone, Arizona. Go online, look up YouTube, look up the really, really good Tombstone movie clips about the gunfight at the OK Corral. Look up what the law was in Tombstone, Arizona. The reason that there were 29 shots in a 30-second period in Tombstone, Arizona, between the Earp brothers and the Clanton gang is the Clanton gang were carrying guns in Tombstone against the law. They were supposed to forfeit their guns, surrender them when they came into town. That was exactly the kind of law that New York had. But Clarence Thomas said, no, that was Arizona. That was a frontier. They weren't actually a state. I'm not going to take this seriously. And he's criticized by Stephen Breyer in dissent, who says, you're just not accepting any of these laws. You're moving around history. You're cherry picking history. You're picking and choosing. And I don't know what you're doing here. I know that New York says they have a desire to keep society safe. And what it requires them to do is to regulate the ownership and carrying of guns outside the home. And I can find lots of examples in history that tell me that that is a valid use of the legal authority of the state. So what we're seeing here is the effort by the current court to change the meaning of the originalism technique. And in changing the meaning of the originalism technique, they can change the result in the case, and they can reach the result that they want. Now, I just want to mention this briefly because this is a discussion of the First Amendment. But if you look at the case dealing with the praying football coach, Kennedy versus Bremerton School District, and the question of whether or not a coach can go out on the 50-yard line after a football game, sometimes the homecoming game, and lead his student athletes, his team, in a prayer, and maybe lead the student athletes from the other team in that prayer, and maybe some parents also, in full view of parents in the audience waiting for their sons to go with them, go home, some of whom do not believe in the views that are being expressed by the coach. How do you do this? Well, if Gorsuch were to use true originalism, he would go back to the framing of the First Amendment, and he would know that James Madison and Thomas Jefferson would never have allowed this coach to do that. He would know that Thomas Jefferson and James Madison saw a high wall of separation between church and state. He would know that the teacher, as the representative of the school district, of the school board, of the school administration, of the state that he was in, he shouldn't be coercing or compelling those student athletes to participate if they want to continue to play on the team. All of these issues would be raised, the issue of coercion. But that's not how Gorsuch said it. How Gorsuch said it was, I'm going to look at history and tradition. He called it historical and practical understandings. I am just going to evaluate based on my review of history, my idiosyncratic, unique view of history, how far that coach can go. And he argues the Constitution and the best of our traditions counsel mutual respect and tolerance, not censorship and suppression for religious and non-religious views alike. Sonia Sotomayor, in dissent, called him out on this and said, you just can't use history and tradition. You have to use precedent. And she argues in dissent, for now, it suffices to say that the court's history and tradition test offers essentially no guidance for school administrators if even judges and justices with full adversarial briefing and argument tailored to precise legal issues regularly disagree and err in their amateur efforts at history. How are school administrators and faculty supposed to adapt? This is the debate that's going on now. It's a debate between history and tradition justices, originalist justices just like Scalia, and one of them would be Amy Coney Barrett, textualists like Neil Gorsuch, progressive originalists like Ketanji Brown Jackson, and people who are using public policy and political science and past precedent like Elena Kagan and Sonia Sotomayor. As I said, you can understand this better if you have your political science hat on rather than your legal hat on. I want to finish this section with one more piece of information. The history and tradition people need to find the right dictionary to give them the right definition of the words in the law or the Constitution to help them to reach the right result that they're looking for. And we are in the age, as you all know, of artificial intelligence. We are in the age of digital humanities searches, keyword searches in large meta databases of all of the writings on different materials. When you understand all of that and apply it to the legal field, here's how it works. What if you took a subset of certain kinds of literature, certain kinds of cases, certain kinds of thinkers? What if you took millions and millions of pages of all of these documents in different eras on different topics? What if you made it possible for a judge with a certain ideological viewpoint to go to a database that has been built, this has been crafted, all of the material put into the database is where this judge would want to go or where that law firm would want to go? And what if you say to that judge, you can now pick a year, pick a topic, pick a word, pick a phrase, and find what you want you are now making it possible for that judge to always reach the result that they want to reach. I have just described to you the debate that is raging now over something called corpus linguistics, Corpus linguistics. You can look this up online. You can go into these databases yourself. Large databases that allow people to go into those databases, look at what the meaning of a word was in 1944, see that the use of this word mask at that time by that judge or that legislator is different from how the word is used now in the COVID pandemic. And you can use that definition to say, and thus I'm going to overturn this mandatory mask provision. This debate over corpus linguistics shows us exactly how political all of this has become. And it's another piece of this history and tradition technique that bears watching as we try to understand where the court is going next and why they're going that way.